You're listening to WCAT Radio, your home for authentic Catholic programming.
Welcome, everyone, to a webinar entitled Bioethics in the Law, Understanding the Nexus, presented by Father Thomas Davis. My name is Sebastian Mahfood, and I am the director of ITEST. The Institute for Theological Encounter with Science and Technology, ITEST, is an association of theologians, scientists, and others committed to a Catholic worldview, in which faith and science collaborate in exploring the truth. ITEST explores truth theologically in the wisdom traditions of the human community and in the data studied in the sciences. ITEST's mission is to foster and disseminate the Catholic position that science and faith are complementary paths to human fulfillment. Before I introduce our presenter, Sister Carla May Streeter, a Dominican sister and professor emerita at Aquinas Institute of Theology, will lead us in prayer. Sister Carla May.
Morning, everyone. For just a moment, please quiet so that we can be in touch with the mystery that surrounds us all. Most Holy One, our most basic resource is our very humanness. Gift us with your spirit and your wisdom to tend it with attention and without neglect. You have provided law that our lives may be ordered as we live among others. Gift us with the wisdom of this presenter, that together we might give you great joy. We pray this in the name of the one you have given us to show us the way home. We pray in Jesus' name. Amen.
Amen. Thank you, Sister Carla May. And now, I'm delighted to introduce our presenter, Father Tom Davis, the pastor of St. Anne Melkite Catholic Church in Danbury, Connecticut. He is a graduate of Fordham University, Quinnipiac University School of Law, and New York University School of Law. He earned his Master of Arts in Moral Theology from Holy Apostles College and Seminary in Cromwell, Connecticut. Father Tom is the founder and director of the Liberty Institute for Faith and Ethics, LIFE, a multidisciplinary center dedicated to scholarship in study of cultural, legal, and bioethical issues. LIFE's website and its bioethics library may be accessed at libertyforlife.org. That's liberty, the number 4, life.org. Father Tom is also the faculty chair for the Graduate Studies concentration in bioethics at Holy Apostles College and Seminary. He is the author of several scholarly articles on a range of bioethical issues, as well as book chapters and articles in the popular media. Father Tom served as an Assistant Attorney General of the state of Connecticut for 30 years. Father Tom's presentation is subtitled Bioethics, Babies, and Bromides, Truth and Meaning in Constitutional Jurisprudence. With that, I give you Father Tom. Father Tom, take it away.
Thank you, Sebastian. Thank you very much. Good morning, all. We're going to study law, basically constitutional law, American constitutional law, and try to develop the nexus between that and the major bioethical issues, or at least some of the major bioethical issues that we commonly encounter within Catholic range of thought. And that Catholic range of thought is just as broad and just as wide as a secular bioethics approach. Perhaps we come to different conclusions, and at other times to the same conclusions as more secular focused bioethical inquiry. So that's our objective, and there is a connection. Now, the subtitle, Bioethics, Babies, and Bromides, should suggest to you that there might be some humor. I certainly hope some humor in the course of this presentation, because there are passages within the case law we're going to look at from our Supreme Court that can draw a chuckle. Bromides sometimes is thought of as medication. Other times it's thought of as ephemeral and weak argumentation slogans. And there's a lot of those in some of the case law, and we'll be talking about some of those. So we're going to have to dive deep into history, because to understand the modern case law that touches on topics like marriage, contraception, abortion, technological assistance and reproduction, end-of-life issues, assisted suicide, even on extraordinary and ordinary care in medical contexts, we need to understand the template by which the Supreme Court of the United States, examines these questions and their conformity with law, and what kind of supra-law oversees the entire structure of our legislative and administrative functions of government. So to do that, we have to go quite a ways back to a case that many of you have heard of over the years. It's called Marbury versus Madison. It was an 1803 decision from the Supreme Court, and it established a fundamental principle that we have to understand, and I believe is essentially unchallenged by any respected jurist or any respected legal scholar I have ever encountered. I have encountered some on the internet who challenge it, but I don't think those people really have a solid grasp of the topic at hand. What happened in Marbury versus Madison requires a little bit of a history lesson. The second president of the United States, John Adams, was a Federalist. Congress was controlled by the Federalists. George Washington, the first president, his Congress were Federalist controlled. And what happened in the election of 1800, Thomas Jefferson was elected president. And this led to I think you'd have to say, panic on the part of the Federalists. Jefferson's party, he won the election, and they also took control of Congress. He won the election when Alexander Hamilton, who was a Federalist, threw his support behind Jefferson after many ballots in the Electoral College. The election had been a tie in the Electoral College. Hamilton believed that Aaron Burr, the other candidate seeking the presidency at the time, was a dangerous demagogue and did not trust him, even though he was in his own party, with the enormous power that exists within the executive branch in the person of the President of the United States. And the President of the United States is an extraordinarily powerful government leader, more so than you will run into in parliamentary systems. So when he won the election, the Federalists were concerned that, they were going to lose all their power, essentially, in adopting legislation. And they certainly opposed some of the initiatives the new Jeffersonians were going to follow. So what happened was, in the very final days of the administration of Adams, the Federalist Congress passed a new Judiciary Act. Now, the Judiciary Act, there was an original in 1789, which set up the court system in the United States. It didn't set up the Supreme Court. That existed in the Constitution itself. But it set the number of justices at 5 at that time. And then it created the various inferior courts to the Supreme Court, the district courts that try cases, the appellate system that hears the appeals from the trial courts, also admiralty courts to handle maritime matters, bankruptcy courts. Those are all given by the Constitution to Congress to create and to define the scope of their powers and their jurisdiction. But it also, the Constitution provided the president with the power to nominate those who would serve as judges and justices in the federal system. So 3 days before he was to leave office, Adams nominated a whole slew of 42 justices, which is a huge number. And they're all for a new district. It was called the counties Alexandria and Washington County. That was going to become the new District of Columbia once the federal government would move there, which had long been anticipated and was part of the plan of the original system. But in order for those justices and justices of the peace and so forth to have their offices, Adams stayed up late into the night, signing the official commissions for all 42. Once he did that, he delivered the 42 commissions to his Secretary of State, because the way the laws work, the president nominates, the Senate immediately the next day confirmed all 42. So the Senate confirmed justices, which is required by the Constitution. He then signed the commissions and gave them Secretary of State. And the Secretary of State then affixes with a seal, the Great Seal of the United States, to each commission. And then each commission has to be delivered to the individual who's appointed. And that completes their appointment. Well, time's running short. The clock is short. They had, 3 days to do all of this, and no bridges across the Potomac, no highways, right? It's horseback. So James Madison was the Secretary of State. He was going to become a future president. Actually, let me back up from that. Madison was the Secretary of State that Jefferson appointed. The current Secretary of State in those last few days was John Marshall, who was also the Chief Justice of the Supreme Court of the United States. He had recently been appointed to that. It's an unheard of conflict that couldn't happen today, but in those days it happened. You had the person who was Secretary of State just so happened for a very brief period of time to also be the Chief Justice of the Supreme Court. So he took those commissions from the president, affixed the seal, and gave them to his brother and said, deliver these to the 42 people quickly. So he was able to deliver 19 of the commissions to the people who are in Alexandria County, but he didn't get to the ones in Washington County. One of those people in Washington County, before time ran out, there was 23 more commissions. One of those persons was William Marbury. And when Jefferson took office, he immediately told the new Secretary of State, who was James Madison, don't deliver the commissions. Just hold them. Those guys can't take office or do anything without the commissions. So Marbury, feeling aggrieved by this, filed a lawsuit with the Supreme Court of the United States. And he asked the Supreme Court to order, by a thing called a mandamus, that the Secretary of State now deliver his commission to him. And so the Supreme Court took up the case. Now, there's a wrinkle in all of this, which is quite outside the scope of the merits of the matter. And that is whether or not the Supreme Court of the United States was the correct court to be going to. Now, when the original Judiciary Act was adopted in 1789, Congress gave to the Supreme Court the power to hear writs of mandamus in cases involving officers of the United States, which would be these almost fully appointed people. The question is whether Congress could do that, because Article 3 of the Constitution, which established the judicial system in what's known as Article 3, Section 2, Clause 2, provides what's called the original jurisdiction of the Supreme Court. Now, original jurisdiction is to be distinguished from appellate jurisdiction. Original jurisdiction means you go right to that body with your original complaint to try your case and get your initial remedy, and then there's an appellate process that might follow. But the Supreme Court, in a very narrow group of cases, has original jurisdiction. So if it's a case involving an ambassador to the United States, certain other public ministers and councils, if it's lawsuits between states, those cases go directly to the Supreme Court, and the Supreme Court then decides whether it's going to hear it or issue a remedy or whatever. The question is, did Congress really have the authority to give the Supreme Court jurisdiction for writs of mandamus involving appointments of public officers? And if it did, then they would hear Mr. Marbury's case and decide the case. If it didn't, they'd have to say, gee, we don't even get to the merits really of this case. We don't have original jurisdiction. We only have appellate jurisdiction. So he has to go to a different court, one of the originally lower court, district court, whatever court he may be appropriate, try his case there, get a result. If he likes it, great. If he doesn't like it, appeal it, and eventually work its way to us in the Supreme Court. Now, that meant if the court was going to take that view, and it did take that view, and that was John Marshall's great achievement as Chief Justice, probably the most enduring, most important decision in the history of the Supreme Court. He essentially said that you can't modify the Constitution by a legislative act. The Constitution is a supreme organic document. And when it established the jurisdiction of the Supreme Court, that could not be enlarged or contracted by legislative vote. You'd have to amend the Constitution itself, which is a very difficult process. We have 25, I'm guessing right now, 25 amendments to the Constitution. Some of them are very well known, right? Women getting the right to vote, the repeal of prohibition, equal rights. So there's quite a few, and we'll talk about some of those today. But the point here is that the court concluded that when Congress adopted the original Judiciary Act of 1789 and gave the Supreme Court of the United States mandamus jurisdiction, or original mandamus jurisdiction over disputes involving public officers, that it didn't have the power to do that. It was acting ultra vires. And in a famous quote from that case, the justice said, "It is emphatically the province and duty of the judicial department to say what the law is." Now, that doesn't mean to make law, to make up law. So, okay, we're going to say you have to drive on the right side of the road, or the speed limit is whatever it might be. Or there can't be discrimination on the basis of race. Those are issues, at least back in those days, that fell to legislatures, competent authority. But if there's conflict, it's for the court to decide what the law is when there's conflict. In this particular case, there was a conflict between the Constitution and the Judiciary Act that tried to modify original jurisdiction. And the court said it's the power of the court to rule and decide that question. And it's not reviewed. Once the Supreme Court says it, that's it. There's no political remedy to that other than amending the Constitution of the United States when it comes to a constitutional issue. So the court declared that the act was in disregard of the Constitution, was not in conformity with the Constitution, and therefore it was not a valid jurisdictional grant of original jurisdiction to the Supreme Court. Mr. Marbury was in the wrong court. Not only that, but he also said, which was not necessary for the decision, he said, Marbury's obviously been wronged, and he obviously is entitled to his office, but we're not the place to go for it. Now, a lot of commentators suggest that the court essentially gave an advisory opinion about the merits, which courts don't do. In our system, courts do not issue advisory opinions on constitutional law. Perhaps the reason for that in that case, which is ancillary to the whole main point, is political. The Chief Justice was a political foe of the new president. And there was always a question of whether or not, this early stage of the Republic, if the new president would accept the decision, or his majority in Congress would accept the decision of the Supreme Court on this issue. But what he did was very clever. He said, Mr. President, you've done something terribly bad. You violated the rights of Mr. Marbury. He's entitled to his commission. You're out of bounds. But I'm also going to assert a doctrine of judicial review, the power of the court to decide what the law is in a given case, which Jefferson was not a fan of. And I'm going to deny Marbury a remedy in this court. It's 1803. Original appointment was 1801. By the time that happened, Mr. Marbury was on to other business in life. He was a Baltimore guy with a shipping business, and for whatever reason, never bothered to pursue the matter further. And so Jefferson was scolded. The doctrine of judicial review was firmly rooted, but Marbury didn't get the position, nor the other 23 or 24, whatever it was, persons who were approved by the Senate. So in some sense, Jefferson got something out of it too. So the result of all of that was a very delicate question in the foundational history of our country. But the decision was accepted. There was no big uproar about it from the anti-federalists, the Jefferson Party, and the matter became very settled law in our nation, and it's never been challenged again. Now, that sets up a basic concept, right? Judicial review, which was well written about and proposed in the Federalist Papers by Alexander Hamilton, John Jay, and I forget who else. There was one other author of the Federalist Papers. These were papers that were written and published during the time period between the congressional proposal, the Continental Congress proposal of a new constitution in 1787, and its ratification by the necessary number of states in 1789. So in that time period, between those two dates, a whole series of papers, very scholarly and philosophical writings, were presented in the popular media to draw attention to the issues that needed to be corrected in the original Articles of Confederation, which created a weak central government and led to all kinds of problems in the administering of a national government, as well as the funding of a national government. And were very persuasive in getting the Constitution ratified by the necessary and eventually all of the 13 states. So that's the background for judicial review. That's critical because everything we're going to talk about is going to involve the function of judicial review. And you'll encounter many people in popular blogging who, in my mind, are highly ideological and politicized, who will argue that, yeah, you don't have to obey the court. You know, if you don't like the decision of the court, just tell the court to stick it. What are they going to do to you? Those are extreme outliers in the American system. There's not a single mainstream voice in American politics or law that supports that position. Okay, the next major development that follows the doctrine of judicial review is another decision by the same Chief Justice. And that's in 1819. And that case is McCulloch versus Maryland. Now, what happened there was really boring. I'm sorry, we have to go into boring sometimes. And it's not a bioethical issue at all. It's a question of whether or not the Congress of the United States can create a national bank, because they did so. And in the state of Maryland, Maryland taxed any bank that didn't have a charter from the state legislature to be in existence. So if you weren't established by the Maryland authorities or identified and recognized by the Maryland authorities, you had to pay a tax. Well, the new national bank had an office in Maryland, and the head of that bank, who was James McCulloch, that's why he's a party in this case, McCulloch versus Maryland, McCulloch refused to pay the tax. He said, we're a national bank. We're adopted by the Congress of the United States. Congress is the only one who can tax us. We're not paying your tax. So that challenge went to the Supreme Court. And the question was whether or not Congress really had the power to create a national bank. Because it doesn't say that in the Constitution. And the Constitution in our system is a delegation of limited powers. Government is the federal government, and we got to distinguish between federal and state. We'll do more of that, drawing those critical distinctions as we go. But the idea is that the government nationally only has the power that is granted in the Constitution itself. It isn't a restriction on the freedoms of peoples or a total grant of all authority to government. Government's identified in its branches of separation of power and given specific powers to each branch. Now, in Article 1, which sets up the legislature, and Section 8 of Article 1, which is a critical piece, and everybody should go back and take a look at it to understand some of this. But Article 1, Section 8 says that Congress has very express congressional powers. And among them are the power to tax, borrow money, regulate commerce with foreign nations and between the states, establish bankruptcy laws, coin money, establish post office, declare war, raise and support an army, and so forth. So these are specific grants of power. I think it enumerates 16 or 17 express grants of power to Congress. And then in Clause 18 of Article 1, Section 8, it then says, Congress also has the power, I'm going to quote this one, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. So in this battle between the national bank, Mr. McCulloch, and the state of Maryland seeking to tax it, the question was, from Maryland's point of view, this bank has no right to exist by act of Congress. Therein are jurisdiction, so we can't stop Congress passing laws, but we can tax it because there's no power in Congress to really create it. And if they're here functioning, they owe us tax money. Well, the Supreme Court examined that question, and they made reference to that Clause 18, that clause that said Congress can also adopt laws that are necessary and proper to carry out its express powers. And remember, in those express powers was coining money, regulate commerce, borrow money. The court looked at those express powers and said, this clause that says you can do things that are necessary and proper to carry out those express powers has a meaning that was understood in the adoption of the Constitution and was in fact discussed in the Federalist Papers. And what they said was, let the end, that is the law adopted, be legitimate, let it be within the scope of the constitutional powers, and all means that are appropriate and plainly adapted to that end, and were not otherwise prohibited by the Constitution, are consistent with the Constitution. So the necessary and proper clause was interpreted to mean appropriate and plainly adapted. Now keep that in your mind. It's a very important phrase. So it doesn't have to be an express power. There has to be an express power, but the means by which you bring it into effect don't have to be literally necessary, as we would use the term today. If the means chosen are appropriate and plainly adapted to that power, such as establishing a bank, because you're going to coin money and you're going to spend and you're going to borrow money, then Congress can do that. What that does is that sets up a relationship between an express power and a law adopted by the entity that has that power. Today, we use different language to describe that. So we're going to change our language for the rest of this class, the rest of this webinar. And we talk about means that are appropriate and plainly adapted. We're going to use what's called the rational relationship test. And this is the test by which courts determine whether legislation, and in the modern era, whether regulatory action by agencies that are given power by legislative bodies to adopt regs, whether those are valid. The test is whether or not there's some express power given to this body, Congress in this case, and there is a rational relationship between that power and the means by which they've chosen to exercise that power. It's a simple test. And rational relationship doesn't mean brilliant. It doesn't mean perfect. There's a famous speech, actually it was an interview with the late Justice Scalia in New York Magazine about 20 years ago, more than that maybe, in which he was pointing out that rational relationship doesn't require a lot of intellectual heft. If there's any rationality between the means chosen and the original power that the entity has, that's enough. It can be unwise. It can be detested by the vast majority of people. That doesn't matter. The power rests with the governing body to make rational relationship decisions. So if you live on a historic district, like in my town, I live in Newtown, Connecticut. We have a beautiful Main Street with a big flagpole in the middle of the street and beautiful, I won't say the colonial, but 19th century homes up and down Main Street. And there's a special zoning borough for that street and its immediate environs. If they were to pass a zoning regulation that said, we want every house on this street to have clapboard siding to reflect its historical era and paint it white, that'd be a pretty extreme thing to do. People who pass a law like that may never get reelected, which is why usually really stupid stuff doesn't get adopted typically. But if they wanted to pass that, and they claim that that's going to increase tourism and bolster an economic incentive, that they're going to gain tax revenue through sales and restaurant activity up and down that strip of road and preserve its historical character. That would be a rational relationship. It might get a little bit further afield if they said everybody had to paint the house lime green or hot pink, because you start to wonder if there's really rationality there. But to express this concept of rational relationship, which is one of the core topics that's going to rest in all of the bioethic issues that come up. There was this famous quote from Scalia. He said, "I wish that every judge in the country, when they're sworn in, receives a stamp." You know those old stamps, you'd have an ink pad and you'd have a stamp in your hand, you'd ink pad it, and then you'd stamp some document. He wanted a stamp that says, "Stupid but constitutional." He thought that would resolve most cases challenging law that comes before courts. It's a stupid law, but it's constitutional because there's a rational relationship, no matter how thin that rationality is. In fact, even if the express reason stated by the legislature in adopting something turns out to be irrational, but some other rational reason exists, the law is valid. So that's the basic structure of law in relationship to legislative enactment, and it governs easily in excess of 90 to 95% of everything that gets adopted as law in our nation. Everything from driving the right side of the road to red light means stop and green light means go, to children are obliged to get educated at a certain level, to setting age for voting and for alcohol consumption. Just about anything you can think of, the vast majority of laws are governed by this rational relationship test. You'll often hear about challenges in local courts and in local small communities where someone says some rule of law adopted by a county board or a city legislative council is arbitrary and capricious. That's another way of saying lacks rational relationship to their powers. So a lot of local zoning fights and other kinds of debates that involve insular, smaller communities, challenging things as arbitrary and capricious exercises of government, are really constitutional issues of rational relationship between power and the means chosen to effectuate that power. So that's one concept of reviewing law, and that's called rational relationship test, and it's drawn directly out of McCulloch versus Maryland in 1819. Now, not everything that we face in law is governed by rational relationship. It took a while for it to develop, but we have certain issues in our society that are elevated above that test, that require a much greater government explanation for what it's doing. In the rational relationship test, critical to understand is that if you want to challenge a law, the burden is on the challenger to demonstrate that either the body that made the law didn't have the authority to act, or the means chosen were not rational. So the burden's on the challenger. It's an extremely difficult burden to sustain. It's seldom successful. It's extremely rare that a rational relationship test cannot be satisfied by a government entity. For one basic reason, the vast majority of people enacting rules and laws, they know about the law, they know rational relationship test. They have subcommittees that study these things, and they establish, usually, very easily, rational reasons for what they're doing. Okay, but what about when you have express liberties that affect individuals, such as the right to free speech, religious free exercise, the right to not have soldiers quartered in your home during times of peace, that's the Third Amendment, the right to possess and bear arms, the right to counsel if you're arrested and charged with a crime that could end up with incarceration, the right to compel witnesses to appear at trials by use of subpoena, the right to be tried for a criminal offense in or around the area where it's allegedly occurred, so you have access to information and data and witnesses, and so forth. So there's the express constitutional liberties in the Bill of Rights. The first 8 of those constitutional amendments are generally recognized as fundamental liberties in our society. And for the government and then there's, on top of that, following the Civil War, there was the adoption of the 14th Amendment, which provides that states, just like the federal government, have to provide due process before they can infringe on someone's life, liberty, or property, and also must guarantee equal protection of the law to everybody. So, over the course of many decades, the court examined situations in which legislative enactments and sometimes executive action seem to, or obviously did, press in upon things like free speech or free exercise of religion or the right to counsel or any of these matters that I mentioned. And what the court has came up with is a test that is markedly different than the rational relationship test. For one reason, is that it's going to shift the burden of proving something from the individual challenging to the government. So the government is going to be put to the burden to demonstrate the legitimacy of why they're doing what they're doing. Burden shifting is a very important concept about who has to prove things. So it began in its greatest, most modern manifestation with a seemingly meaningless thing. Of course, this is going to affect all kinds of topics, either rational relationship or what I'm going to describe to you as a heightened scrutiny. It's now called strict scrutiny. It had different names over time. It began with a sort of a surprising kind of case, and that was the United States versus Caroline Products Company in 1938. And it's because this company was shipping adulterated milk interstate, what was called adulterated milk. Whether it's not, it was actually adulterated is a debate about the facts. We're not going to get into that. But there was a special law from the 1920s called the Filled Milk Act that prohibited the transportation of adulterated milk across state lines. And the court concluded, well, this is a commercial transaction, ordinary, normal commercial transaction, and it's subject to the rational relationship test that we've discussed. And they said, sure, there's a rational relationship between interstate commerce and commercial transaction, and Congress has the power to regulate interstate commerce. And this particular rule they established, they're trying to protect certain industries that they think need some kind of protection. It's rational. You might not like it, you might not agree with it, but it's rational. It's all it has to be. But in a footnote to that decision, one of the justices, Justice Stone, wrote something striking. He said that the scope of review by the court and this presumption that whatever legislatures do is legitimate and constitutional, rational relationship, might not always be the test to apply. That sometimes the test will require a more exacting judicial scrutiny. That's the phrase, more exacting judicial scrutiny. He mentioned that this could be something that might apply with things like the right to vote, because there have been decisions on this previously, but nobody had articulated the test. The right to vote, the right to disseminate information, which is a First Amendment right, interference with political organizing, the right to peacefully assemble, and so forth. He said, in those cases, we might want to consider whether there is a different kind of test to examine legitimacy of government conduct. And sure enough, it didn't take long until a very famous, we might say infamous case came along in the 1940s in World War II called Karamatsu versus United States. Now, Fred Karamatsu was a very loyal Japanese American living on the West Coast. But he was ordered to vacate, along with many Japanese Americans, and to be located somewhere else because of an executive order when the war began by President Roosevelt that appointed military commanders for every place on the globe. And those military commanders were given power by the commander-in-chief's authority to decide what human beings are allowed to be in those territories, anywhere in the world, because it's a world war and we claim that power And one of the things those military commanders promptly did was to order, and of course, the military commanders didn't act on their own. Military commanders have political connections as well. They were operating in direction of what the president wanted them to do. That Japanese Americans have to leave the West Coast. Many of them were interred in really rough condition camps in Montana and Idaho and elsewhere. Very famous circumstance. What the court said in that case was that the government had certain powers to protect the nation in time of war, and that it would not be enough to satisfy that by rational relationship, that the government is going to be put to the burden instead of the challenger being put to the burden, instead of Fred Karamatsu being put to the burden. The government is put to the burden to establish that they have to do this to protect the country. And they applied a more exacting standard of scrutiny, but they held that that level of scrutiny was satisfied, and they upheld the exclusionary orders of the Japanese Americans. Now, one of the justices dissented from that and criticized the decision as a raw exercise of racism, as I think most people recognize it to be today. For our purposes, the facts of the case are less important. We're interested in understanding the development of this concept of the more exacting scrutiny, which becomes known as strict scrutiny. This is the very early example of it. And it's commonly used today in cases that involve contraception, abortion, marriage, family life, assisted suicide, and so forth. If the topic falls within a category that gets this concept called strict scrutiny, the government has to prove that it has a compelling reason to be acting as it's acting. First, of course, it has the power. It has some authority to be in this topic at all. And then if they're in that topic, they have a compelling reason to be there, and there isn't a compelling reason to interfere with somebody else's freedom, and that they cannot achieve their compelling need by some less offensive or intrusive means. So this is called strict scrutiny. It has to be compelling government interest achieved by the least restrictive means. And that burden is on the government. So when strict scrutiny is applied, it's extraordinarily rare that the law is sustained. It's almost always declared unconstitutional. There are some exceptions. When it's rational relationship, the burden is on the challenger citizen or corporate entity, or whoever the challenger is, and they're at the burden to prove no rationality, and they typically lose, and the law is sustained. That's a stark distinction that governs a lot of law that we're going to talk about in bioethics. Now, certain rights are fundamental, and they're going to get strict scrutiny whenever they're implicated by government conduct. First Amendment, Second, Third, Fourth, Fifth, Sixth, Seventh, Eighth Amendments almost always are going to run into that issue. However, there's also in at least one circumstance what's called intermediate scrutiny, somewhere in between rational relationship on one hand and strict scrutiny on the other. It's called intermediate scrutiny. It has a few other names. And the reason intermediate scrutiny developed was that there were challenges to sex-based distinctions in laws that applied differently to men and women. And people challenged those laws, claiming it should get strict scrutiny. Others said, no, all it needs is rational relationship. The court said, well, it's somewhere in between. And they said that rather than adopting strict scrutiny, because the Equal Rights Amendment had been proposed by Congress, had been sent to the states for ratification, and it failed. So the Equal Rights Amendment to the Constitution was not ratified by the necessary number of states. So the court concluded, it's not up to the court to create new constitutional liberties. Those things belong to the elected representatives acting in Congress, proposing amendments to the Constitution, send them to the states to see if they're ratified, or by the states themselves calling a new constitutional convention, which has never happened. but which, by the way, there is a movement today to have a new constitutional convention. And it has substantial support. I think you need 2/3 of the states to call a constitutional convention, and they're only a few states short of that number. You call a constitutional convention, the whole ball of wax is up for rewriting. It's not like you call a constitutional convention just to examine one issue. Everything can be amended by this convention. That convention would then have to submit its proposals to the various 50 states and get the necessary supermajority to approve it to become a new constitution. So there are some very dramatic background issues floating around that issue. But intermediate scrutiny exists in sex-based distinctions. And the two cases that I'm aware of, Craig versus Bourne, prohibited the sale of intoxicating beverage to males under the age of 21. But women, only if they're under the age of 18. So women were able to buy alcoholic beverage for a 3-year time period of age where men could not. And the challenge came to that law. And the Supreme Court adopted rationality wouldn't be enough to sustain that sex-based distinction, but it wouldn't be the burden to the government of showing a compelling interest achieved by the least restrictive means. In this particular case, the legislature of that particular state was arguing that we need to restrict the sales to younger men because they get drunk and get in car accidents, and there's high fatality and live injuries, and that's certainly borne out by the actuarial data. No question about that. The factual foundation for that is true. What the court said was that in this particular case, the level of need that the state of Oklahoma could bring to that decision was inadequate, and they declared that distinction by age to be unconstitutional, applying this intermediate level test. We aren't going to be talking much about intermediate scrutiny. Our distinction is going to be today, for the topics we're going to examine, rational relationship versus strict scrutiny. And you get the big point. If the topic at hand involves a fundamental liberty, strict scrutiny is going to make it very difficult for the government to get in there and do anything. If it's rational relationship, the government has a very broad free hand to act. All right. Now, I want you to back up for a moment because the Karamatsu case is such a controversial matter. I don't want to leave it uncommented on. At least someone think that I'm not appalled by the outcome of that case. It's just not really, the outcome isn't really our topic today. But I don't want to either paint the decision makers of that time as obviously racists. Perhaps, I don't really know. In the case of Trump versus Hawaii, which is a 2018 decision, in which the Supreme Court sustained decisions by the president to exclude entry into the United States of people from various countries around the globe, allegedly for national security reasons. The court said that Karamatsu was gravely wrong the day it was decided and has been overturned in the court of history, and to be clear, has no place in law under the Constitution. That last phrase was quoting Justice Jackson, who was the dissenter in Karamatsu. But the Supreme Court did not actually take a vote or declare Karamatsu overruled. And the reason for that, I think, is it would not be overruling the test, right? The underlying examination of this more exacting scrutiny. Obviously, you have to apply a more exacting scrutiny for a race-based or a national origin-based or ethnic-based distinction in law. So that part of Karamatsu made sense. Applying it was a nightmare, frankly, right? Okay, one of the reasons the Karamatsu case stood as long as it did without an express statement from the Supreme Court about it was a companion case called Harabayashi versus United States, which was decided as a companion case almost at the same time. That case involved a fellow who would not respect, he was challenging a curfew on Japanese Americans. Some of the history of those days is worth noting to understand the context, not to excuse the outcome, but to understand the context. There was a great deal of concern, justified or not, about a fifth column in the United States that would sabotage and undermine our war effort. The United States was gravely ill-prepared for World War II. Many historians have taken the view that had a full-scale invasion of the United States been launched by the Japanese or by the Germans coming from the other coast, the United States would have been a very difficult time repelling that attack. What happened then was a memory of something that happened during World War I. During World War I, the German military apparatus was able to infiltrate New York Harbor and blow it up. So in 1916, the Black Tom affair, New York Harbor was destroyed, which was the major harbor of the United States. And much of the supply being sent across the Atlantic to Great Britain and to France, but basically Great Britain, was coming out of New York Harbor. So there was concern this kind of thing might happen again. And to give a context, there is a quote from the Hirabayashi case that might give you an insight into the mindset of those who were charged with the defense of the homeland. It said on December 7, 1941, the Japanese Air Forces attacked the United States Naval Base at Pearl Harbor without warning. At the very hour, its diplomatic representatives were conducting negotiations with our State Department, ostensibly for a peaceful settlement of differences between the two countries, simultaneously, or nearly simultaneous. The Japanese attacked Malaysia, Hong Kong, the Philippines, Wake and Midway Islands. The following day, their army invaded Thailand. Shortly afterwards, they sank 2 British battleships. By December 13, Guam had fallen. By December 24 and 25, they captured Wake Island, occupied Hong Kong. By January 2, Manila fell. On February 10, Singapore, the great naval base in the east of the British. On February 27, the Battle of the Java Sea resulted in a disastrous naval defeat for those nations united against the Empire of Japan. By the 9th of March, Japanese forces had control over the Netherlands East Indies, Rangoon, Burma, Bataan, and Corridor. The result of the attack on Pearl Harbor was not fully disclosed to the public until much later, but what was known is that it was extensive damage. They go on to say, the reasonably prudent men charged with the responsibility of our national defense had ample grounds for concluding that they must face the danger of invasion and take measures against it. And in making the choice of measures, consider our internal, that would be sabotage risk, situation cannot be doubted. So that would have been the underlying thought process that the commanders and the president had at the time, certain leaders of our political system. As we've discovered over time and in history, there was very little evidence to support that. This was based, you might say, on paranoia that somehow translated for those who had been through the Black Tom affair into realism. A very unfortunate situation, but that's what happened. Okay, so you have these 2 basic tests. Now, there's one other development to be aware of, because it doesn't just apply, the strict scrutiny test doesn't just apply to fundamental liberties of the first 8 amendments to the Constitution. It also applies to the equal protection of people. The 14th Amendment, adopted after the Civil War, was adopted primarily to begin the eradication of discrimination on the basis of race by the government. Right? All these rules apply to government conduct. So, in legislative distinctions that are basing rules on race, few other categories, religion, ancestry, national origin. In those categories, The court also applies this test of strict scrutiny. The government is put to the burden of showing they have a compelling reason and need for doing what they're doing, if they're making a distinction based on race or religion, on laws that apply to people. And they must show that there's not a least drastic alternative to the means they've chosen. And very few laws that are challenged under strict scrutiny, if in fact strict scrutiny applies, very few laws survive that challenge because we don't allow, without absolutely compelling need, restrictions and distinctions based on those kind of categories. So it's fundamental liberties, and it's the classification on those four categories: race, religion, national origin, and ancestry. Now, that doesn't conclude the whole thing, because there is also another category that can draw strict scrutiny and then escape the simple review of rational relationship. And that comes into a category of unenumerated liberties or unenumerated rights. So it's been a long, and that's what we're going to review a great deal of now for much of the rest of this discussion. What kind of rights are fundamental in an ordered system of liberty that we will treat them like we treat free speech or religious free exercise or freedom from discrimination based on race or religion? Those things are called unenumerated liberties. If you watched any of the confirmation processes of Justice Kavanaugh, it was quite interesting. One of the senators was attempting to grill him on the question of unenumerated liberties. And how would you go about recognizing unenumerated liberties? Whether something is prostitution, a fundamental liberty. It's unenumerated, it's not in the Constitution, but is it part of the concept of liberty? It was a very interesting dialogue that I don't think many people would follow. But Justice Kavanaugh is one of the great scholars of the doctrine of stare decisis, the idea that we respect precedent, and what the conditions are that would come about that would lead us to reject previous decisions and overrule them. And also quite the scholar on this issue of unenumerated liberties. And there was quite an intense, heavy discussion that got off into arcane case law citations of cases that nobody's ever heard of. But I'm going to try and explain how we came to that discussion and why that discussion was so important, project where something was percolating that led to Dobbs versus Jackson's Women's Health, the decision this past summer on the feast of St. John the Baptist that reversed Roe versus Wade and another case called Casey versus Planned Parenthood of Southeastern Pennsylvania. So let me back up now in date and get back to 1891. And I'm using two computers here, so I have all my notes available to me. Okay, so there was a case from the Supreme Court called Union Pacific Railroad Company versus Botsford. And this was no great constitutional law case. This was a personal injury case, passenger on a railroad car. She said she got injured because of negligent repair of the upper berth of her sleeping cabin. And, she fell out of it and she got hurt. She said she injured her spine, her brain, had a concussion, and so forth. One of the things that happened in that case was a request for an independent medical examination. Now, you have to transport yourself back to the cultural context of 1890s, 1888, 1889. This came to the Supreme Court in 1891, so the events probably happened several years before that. She did not want to be examined by a medical practitioner who would either have her disrobe or would be reaching under her clothing, palpitating parts of her body. So this is a great invasion. And at that time, that was generally recognized as an intolerable kind of thing. Even today, requests for independent medical examinations in personal injury litigation are strictly governed by sets of rules. I mean, you can't just pick a doctor and tell him to see this person. There are objections to that. But in those days, the court wrote something that was very important for an understanding of fundamental traditions of American society. They said, no right is held more sacred or is more carefully guarded by the common law. This is not constitutional law. This is the long history of case law, guarded by the common law, than the right of every individual to possession and control of his own person, free from all restraint or interference by others, unless by a clear and unquestionable authority of law. The right to one's person may be said to be the right of complete immunity to be let alone. So this is a long-standing concept in American law, that people have the right to be left alone and not be bothered by government interference where there's some strong reason for it, very strong reason for it. And that underlying concept then emerged in a case called, I thought I wrote the name down, the Society of Sisters. So the Society of Sisters had a private school in Oregon, and Oregon abolished private schools, and everybody had to go to a state school between the ages of 8 and 16, had a public school. So the Society of Sisters and another private academy, a private military high school academy for boys called Hill Military Academy, they sued, and they claimed all kinds of reasons why this violated their rights. They said things like, well, we've invested a lot of money, we built buildings, we have long-term contracts with teachers and families to enroll their kids, and without long-term contracts, we aren't financially stable. We've bought land, uniforms, equipment, classrooms we built out, and all of this, and the profit from it is being undermined, and that's our property being taken away from us without due process of law. The court concluded in that case that parents have a right to choose education for their children, and that this somehow violated. Now, it's not getting into the clear distinctions we make today where we specify Article 2 or Amendment 4 or Amendment 1, but in a generalized understanding of just what liberty is, and the freedom for the Society of Sisters to provide a public religious education, a private religious education to students for families that chose it. That this somehow, the court said, is to be recognized as something fundamental in the rights of American people. And they said that there was no question the government had the right to regulate reasonably what you had to teach. And you have to teach them to read and write. You have to give math classes. You're going to have to provide, so forth. So some world of reasonable regulation, the government has a right to impose on education standards for the very good needs of the nation, our educated society. But to eliminate the right of persons to choose how they'll develop primary education for their children, in what kind of setting, whether it's a religious school or a private academy, violates both the rights of these private academies that had all this investment and so forth, and the parents who would be losing the right to determine the upbringing of their own children. That was a prequel of a bit to Meyer versus Nebraska, which came shortly after. And maybe I'm mixing them up. Maybe Meyer was first. I'm not sure which one. Both were in the 1920s. But Meyer versus Nebraska was following World War I. They passed a law that no one could teach in any private schools were allowed. Public schools are fine. But no one could teach in any language but English. Everything had to be English. Now, the reason for that was the large German American population in that region and the hostility that many had towards the German American population following World War I. World War I was, we think of World War II as the great monstrous conflagration of the 20th century, but World War I was psychologically perhaps more devastating because nothing like it had ever happened before. And the losses were enormous. The losses of life, the number of wounded and maimed individuals, the cost of the society economically were absolutely staggering. There seemed to have been a desire to avoid people learning German and to inculcate the young people into being more American, to forcing a kind of acclimation into values and into society by knocking out the foreign languages from any educational instruction. A particular teacher was arrested because he taught in German, and the Supreme Court held in that case that the law unreasonably interferes with the liberty of parents and guardians to direct the upbringing and education of children under their control. The rights guaranteed by the Constitution may not be abridged by legislation that has no reasonable relation to some purpose in the competency of the state. Now that sounds like rational relationship test, right? And that's the language of rational relationship. But they go on to say, the fundamental theory of liberty upon which all governments in this union repose excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only or in a particular language. And these went on to say that the state may do much, and in fact may go very far in order to improve the quality of its citizens physically, mentally, and morally. That's clear. But the individual has certain fundamental rights which must be respected. And it went on to say in that Myers versus Nebraska case that the interference in this particular matter, language interference, was plain enough that no adequate reason in time of peace and domestic tranquility has been shown. Now, they're not talking at this point in language about strict scrutiny or more exacting standard that was first in that footnote I mentioned from the Carolina Products case. This is all 10 years before that. But you can see how the language is now mixing reasonableness and questions of fundamental freedom. And it's grasping and grappling with the concept of how do we review legislation that's impacting these fundamental things where we have this concept of bodily integrity, the freedom to be left alone, the right of parents to raise children, and how we're going to eventually come about dealing with all of that. When you get then in 1925 to Pierce versus Society of Sisters of the Holy Name of Jesus and Mary. This is a great one. This goes back to the Oregon case. Well, we've already covered Oregon, so I'm going to skip by that right now. We've talked about it. But the final language that came out of these cases, the Oregon case and the Nebraska case, was that how do you decide when a law unreasonably infringes on liberties guaranteed by the 14th Amendment? Now, why did it say 14th Amendment? This is also quite important to understand cases like Dobbs and Roe versus Wade. The 14th Amendment contains a provision that requires that states not deprive persons of life, liberty, or property without due process of law. The Fifth Amendment has the same language, but it applies to the federal government. So both the federal and the state governments are obliged not to deprive persons of life, liberty, or due process of law. But it applies for the Fifth Amendment to the federal government and to the 14th Amendment to the state governments. So you could have the exact same issue. Let's say it's a law that prohibits extended families from living in the same home. And we're going to talk about a case like that. And it's adopted by the federal government. And presumably it's unconstitutional. The courts would examine it under the Fifth Amendment due process clause. If it was the state of Florida that did that, or Nebraska, or California, it would be examined under the 14th Amendment. So it's different constitutional provisions that govern different government entities, which is why we talk about 14th Amendment when the state is the party to the case, and the Fifth Amendment when it's the federal government. So in this particular conclusion, they said, when you have liberties guaranteed by the 14th Amendment, how do we decide about who's allowed to have the right to enter into a contract or to choose an occupation in life? They said these are things that are fundamental in our society. So they're declaring now certain fundamental liberties that are not expressly stated in the Constitution. But somehow the court is saying these things are just as cherished and as protected in our system as free speech or religious free exercise. And they rattle off a few. They say the 14th Amendment guarantees liberty. This has states. It would apply to the federals under the 5th. It would denote freedom from bodily restraint. They can't come in and just arrest you if you didn't do something, right? The right of an individual to enter into a contract. The right to engage in the common occupations of life. The right to acquire useful knowledge. The right to marry. The right to establish a home. The right to bring up children. The right to worship God. Now, the right to worship God is expressly provided in religious free liberty, but the others aren't expressly. So what it's saying here is that we have a recognition that there are fundamental freedoms that aren't actually articulated in the Constitution. And the battles that we have in the modern bioethical debates revolve around whether or not unarticulated freedoms are fundamental or not, and whether or not the court will recognize them as fundamental. Once you recognize it as fundamental, then you apply strict scrutiny to government regulation about it. And strict scrutiny is almost always the death knell to the government action. If it's not fundamental, not in every case, but in the vast majority, you would apply the rational relationship test, in which case the government's going to win almost every time. Now, that's really what this is all about. Now, I'm going to back up for a moment to mention one other case that is no longer valid, has been expressly overruled by the court, but it lays the foundation for the modern era debates. And that's called Lochner versus New York, a famous 1905 decision. And in that case, the state of New York legislated that baking companies may not require their employees to work more than, I'm not remembering the exact, let's just say it's 60 hours a week. It might have been more, but I'm just going to pick that arbitrarily for our discussion. So they could not compel bakers to work more than that number of hours. Now, this particular baking company, they had dormitories built next to their factory, and their employees, who were not complaining for the most part, the vast majority, were complaining about the law, complaining about their working conditions. As working conditions went back in those times, this particular system seemed better than most. They had dormitories set up. They provided them decent meals, housing, proper medical attention if they needed it, and so forth. But they required them to work a lot of hours. And some of these people were happy to work a lot of hours, and perhaps some weren't, and they needed to work. New York passed a law limiting the number of hours. Supreme Court declared that that law was unconstitutional, that it violated a fundamental liberty, so that a mere rational relationship wasn't going to be enough. They didn't get into this distinction between rational and strict scrutiny. They just said, this is a fundamental freedom in our country to contract. The fundamental right to enter into agreements that aren't coercive, you're choosing. And if you want to work 80 hours or 90 hours, that's your business. And a law that would prohibit the baking company and the baker employee from entering into that agreement would be infringing on the right to contract in a way that makes it unconstitutional. Now, subsequent decisions from the court, there was a strong dissent saying this is a terrible decision. When you're dealing with, this is merely a matter of economic regulation and in matters of typical commerce regulation. The federal government has power over its interstate commerce. Local governments have this power under what's called the police powers that state governments have. And this is a valid exercise of those police powers to adopt law for the health, welfare, and morality of society. And all they need is rationality to do that. Eventually, Lochner was overruled in the early 1930s expressly. By the 1920s, it was being rapidly moved away from, as the courts recognized that this would mean you couldn't regulate, you essentially could hardly regulate the economy in any way. And eventually that was overruled. But the concept that was introduced in Lochner was a concept that has been at the heart of the bioethical debates, and it's called substantive due process. That expression haunts Roe versus Wade and is very expertly drawn out in its history by Justice Alito in Dobbs versus Jackson Women's Health. Substantive due process is the idea that when we're trying to find a place to say you have a right to marry, a right to raise a family, a right to establish a home, where does that right come from? We don't find it written in the Constitution of the United States. And what over a series of decisions the court came to saying was, we're really looking at the liberty language of the due process clause, that the right to be not deprived of liberty without due process is not limited to procedural protections, like if you're going to be charged with a crime, you have a right to be notified of the charge against you and the particulars. You have the right to know who's accusing you. You have the right to cross-examine that person. You have a right to a meaningful hearing at a meaningful time in order to challenge. And the burden of proving against you is placed on the government. You have the right to compel witnesses to appear on your behalf, and so forth. These are due process rights, and they're procedural. And they obviously are going to strongly relate to the substantive outcome of cases, because if you don't have those procedural rights, it's a kangaroo court. So there are those who held the view for a long time that the due process clause is purely procedural, and that's all it addresses. In Lochner, the court said that the due process clause liberty language was substantive, that it actually provided a substantive source for various liberties, one of which the liberty and freedom of contract, that was virtually unlimited. It wasn't exactly unlimited, I'm exaggerating, but very, you could contract for 80 hours to work as a baker, even if the law in the state said you couldn't. So the idea of substantive due process was very controversial, and in the area of economic regulation has been entirely abandoned by our system, and we don't apply it. However, it began to be applied in cases involving individual liberties other than the economic sphere. The cases that I described in Oregon and the Society of Sisters and Meyer versus Nebraska, those cases from the early part of the 20th century, was essentially applying that concept without expressly saying it necessarily. Some language in there would suggest they were saying that, but they were applying what looks like substantive due process to find fundamental individual liberties. Now, that begins to reach the modern era in 1965. And perhaps there's a few cases before that, but for the sake of our discussion, we're going to jump to 65. A very famous case, Griswold versus Connecticut. In Griswold versus Connecticut, the question was whether a Connecticut law that prohibited the distribution and use of contraceptives was constitutional. And the Supreme Court declared it was unconstitutional. And instead of relying on substantive due process, which was very controversial, right? It had been adopted in Lochner, had been discredited. Nobody wanted to use substantive due process because you wouldn't get a lot of the justices to agree. It was difficult. The decision relied on a broad collection of rights. It said that various rights in the Constitution, from the First Amendment to the Third Amendment to the Fourth Amendment, privacy in your homes and so forth, that they created a zone, a penumbra, a cloud within which we're protected from government intrusion. And they said that these zones of privacy stem from these various amendments, from the First, the Fourth, Fifth, the Ninth, and so forth. And that in the current case, the right to use contraceptives was a matter of marital privacy. In this case was casted as one of marriage. And a institution that predates the Constitution, the court said. They even called it something sacred in our system, marriage. And they ruled that the Connecticut law prohibiting the distribution or use of contraceptive by married couples was unconstitutional. It was a very short leap to where we became apparent the case was not about marriage. But over time, it was challenged of whether or not you can have these penumbras of rights that flow out of other rights. There has to be something more specific in the Constitution. So it was facing a lot of challenges. A couple of years later, in Loving versus Virginia, the Supreme Court declared that the prohibition on interracial marriage was unconstitutional in Virginia. The Lovings, appropriately named couple, were arrested and convicted. She was black, he was white. In Virginia, that was a crime. It was not a crime for people of different colored races, as the statute read. So Native Americans and blacks or various persons of Asian descent could intermarry without any violating the law. It was only if any of those married with a white person. So it was obviously a racist law. And the court declared that it violated both the Equal Protection Clause, which is a different issue we're not going to talk much about, but also it violated the fundamental substantive due process right to marry. So here we have a recognition, the court now expressly saying substantive due process is not dead. It's true. It's a valid concept, and it applies to fundamental liberties. We're not talking economic regulation. And it is the source of the fundamental freedom in our legal system to marry. So we have that. It's a little shocking to realize that we were 2 years from men walking, a year from men walking on the moon before that case was finally decided and put to rest. Shortly after that, and 10 years later, Moore versus City of East Cleveland, Cleveland had a local zoning ordinance that prohibited certain extended family members from living into the same household. And the court declared that unconstitutional. It was a criminal ordinance. But what they said was, it's a long recognized part of our nation that extended families provide nurture and development and protection, and it goes so deeply back in the history of our nation that it must fall within these fundamental freedoms that are in the substantive due process. Then we got to some very interesting developments. Essentially, we got to Roe versus Wade, in which the court then began to examine whether or not a Texas law prohibiting abortion implicated a fundamental liberty. The Constitution doesn't mention abortion, doesn't mention marriage, it doesn't mention contraception. So, was abortion one of those fundamental liberties that is swept up with substantive due process? Now, the court avoided using the language substantive due process and spoke about the penumbras and the various emanations that were spoken of in Griswold versus Connecticut. That the idea of free speech, free religion, not having soldiers in your home in time of peace, the right to be secure in your person, paper, and property of your own home from unreasonable searches, all these things indicated that a zone of privacy existed. And from that zone emanates specific guarantees. And one of them includes the right to terminate a pregnancy. That's what the court said in Roe versus Wade. It's since been recognized that rationale is not what continued to be the foundation of abortion rights. In Planned Parenthood versus Casey, I think it was 1992, the Supreme Court, by a 5-4 decision, upheld the central holding of Roe, that the right to terminate pregnancy was a fundamental liberty. But they did not ground it in these various penumbras and emanations from other constitutional provisions, first, third, fourth, and so forth. They instead said that this falls within the concept of liberty within the Due Process Clause. And therefore, we're talking clearly at this point, no doubt about it, firmly rooted, the concept of substantive due process. And Justice Scalia issued a very famous dissent to that decision. We won't get into the dissent, take too much time. But he began to challenge whether or not substantive due process was a legitimate matrix for examining this question, untethered from some other rule that hamstrings it. Because otherwise, if you've got enough judges, the doctrine of judicial review, established in Marbury versus Madison, could be applied by the court to throw out anything it wanted to throw out that Congress or a state legislature passed. And this would then, if it ran unbridled without some internal restraint on the judiciary, fundamentally alter the balance of power by separation of powers, and undermine the concept of Republican form of government, that your representatives would not be making law, but that courts would end up making law. So that was an interesting challenge, and it began to reach into other areas. In Lawrence v. Texas in 2003, the court held that an anti-sodomy law in Texas was unconstitutional, and they extend. Now, this is only a short number of years after they had upheld the exact same kind of law. Part of the reason for that is that it did not criminalize sodomy between heterosexual couples, only between couples of the same sex. So you have, in addition to questions of substantive due process, you have equal protection questions. Again, we're not going to deal with equal protection today as much, but they held that there was a substantive due process right for adult consenting individuals to engage in sexual practices of their choosing, even if they're among the same sex. And that would be something that's grounded in the concept of liberty in the due process clause of both the 14th Amendment as versus the states, and the federal government being the 5th Amendment. Well, it was concerning enough people at this point, and even before that, that these decisions were not based on any rule other than what the judges thought or argued were reasonably important topics and needed some protection. It was very ambiguous language. There had been a previous case, Washington versus Glucksberg, in the late 90s, in which there was an attempt to compel physician-assisted suicide by legislation, and to claim that not allowing physician-assisted suicide, if a legislature wanted it, or not just allowing it, even if the legislature disallowed it, violated individual liberty to right to choose when you wanted to die. If you were suffering from an incurable illness with a short period of time, I think in that case, they were arguing for 6 months to live. And in that case, the court held that they refused to recognize physician-assisted suicide as a fundamental liberty. They said legislatures are free to adopt it in state A, state B, state, if they want to do that. That's their power. But we're not going to impose this as a constitutional liberty on the nation, because it's untethered from the history and traditions of the nation. And they announced a rule that unenumerated liberties were fundamental and would be subject to strict scrutiny analysis if they were deeply rooted in the history and the traditions of the nation. And that's the phrase that's critical to understand. Deeply rooted in the history and tradition of the nation. Now, when you get to Dobbs analyzing, or you get the Overfeld, which is the same-sex marriage case, which also recognized a substantive due process right to same-sex marriage, and therefore it's national. It's in the federal Constitution. No state can legislate against it. The important point to gather in there is that if there isn't some rule like the deeply rooted in history and tradition of the nation, then it's left to judges to conjure up, I don't think that's too strong a word, their own subjective rationales. So that the risk is that our judiciary, by a majority vote of 5 on a Supreme Court of 9, could impose a sociological or ideological cultural view as constitutional law without having a connection to history and the tradition of the nation. Where else do you get fundamental liberties from? And the important point there is that when it's a state matter, due process clause under the 14th Amendment, that takes you back to the question of when the 14th Amendment was ratified following the Civil War. What was the understanding of the states that ratified about abortion? Now, in Roe versus Wade, the argument was made that abortion was accepted in many places, that it's really a religious dispute, that nobody can really come up with a definition of life and when life begins or when a person begins. And I should point out that no justice of the Supreme Court has ever said that the unborn is a person. If it was declared a person, then abortion would be mandated as a crime because the Constitution would protect the person. And if you didn't protect them by your laws, you'd be denying them equal protection. But no justice has ever said the unborn is a person. The issue has never been resolved, except in Roe versus Wade, they said the unborn is not a person. A majority said that. Not all the judges agreed. And therefore, since it was not a person, and we know the woman is a person, she wins the debate of conflict of rights because there's no other person in conflict with her. That was the essential rationale of Roe, therefore being a fundamental liberty. In Dobbs, Justice Alito went back and examined, well, wait a minute. That historical analysis by Roe was illegitimate. He went back and examined the status of abortion in every state of the Union at the time the Civil War, post-Civil War amendments were adopted, the 13th abolishing slavery and the 14th establishing the Equal Protection Clause and the right to due process from the states. And he demonstrated that in every state, abortion was criminalized and remained criminalized in every state well through the majority of the 20th century. Some states beginning in 1968, somewhere around there, New York liberalized abortion law to allow abortion in some narrow cases. What that would mean is that abortion is not deeply rooted in the history and the traditions of the nations. When Roe made its decision in 1973, it came up with a right that had no root in American history. And in fact, so I encourage all to read Justice Alito's decision. It's a long decision with a long historical excursion and an appendix in which he provides the actual language of each of those states' abortion laws. There were also debates about quickening, whether or not some states outlawed abortion after quickening, the movement cessation being recognized by the mother of the fetus. But that was based on Aristotle's knowledge of human biological development and the belief that a soul animated with quickening and so forth. Thomas Aquinas may have followed along with that, but he was simply following the biology of the sciences of his day. It wasn't a theological, it wasn't rooted in a theological analysis. He demonstrated that whole debate was a side issue because the states still outlawed abortion. Some of them didn't outlaw it until quickening. Because they had this mistaken view that they were adopting this old idea that quickening represented the existence of personhood at a certain point because the soul animated. Okay, so Dobbs looks at all of that and says, we don't have any deeply rooted history and tradition of abortion. When Roe versus Wade said it did, it was wrong. It was grossly wrong. It was wrong, using language almost identical to what Chief Justice Roberts said in Trump versus Hawaii, commenting on Karamatsu. He said it was wrong the day it was decided, and it's remained wrong all along. There is no such thing as a deeply rooted history and tradition of our nation to support abortion, and therefore it cannot be established as an unenumerated liberty, the same way something like marriage is, or the right to raise children, right to establish a household or engage in common professions, the right to travel where you want to travel. And since it was not a fundamental liberty, then what level of scrutiny is applied to a state law that regulates it? Strict scrutiny? No. Strict scrutiny is reserved to fundamental liberties. Because it is not a fundamental liberty, it's subject only to review by rational relationship test. So a state law that regulates abortion will be sustained and if it can establish that there's a rational relationship between the law adopted and the power of the state with respect to general health, welfare, and morals. The interesting thing there is that, again, the burden shifts. If it's a fundamental liberty, the burden to explain why you're regulating abortion falls on the state to show a compelling need to do so, and no other reasonable, less intrusive means to do so. One of the few times with respect to abortion that the court ever found that there was a legitimate, fundamental, compelling need that couldn't be reached by any other means was the prohibition signed by George W. Bush on what is commonly referred to as partial birth abortion. And that's a colloquial term. That's not a medical term. That's an abortion that's carried out very late in pregnancy, usually by a breech delivery, in which the child is removed from the birth canal and outside the vagina up to around the line of the nipples. And then some device is inserted into behind the child, pierce the back of the head, the suction, suck out the brains, collapse the head, and deliver the child. That the Supreme Court upheld a federal law outlawing that particular means of abortion, and said it satisfied strict scrutiny. It wouldn't have to satisfy strict scrutiny anymore, not after Dobbs. All you need is a rational relationship, the burden not on the government to explain what they're doing, but the burden on the one challenging the law to show that it was irrational. In Dobbs, the court provided 6 specific rational reasons governments might regulate abortion. We don't need to go into all those and just run us off a little bit. But among the rational reasons the court identified was the desire to protect potential live-born birth. Also to protect maternal health. There were 6 different rationales they came up with, all of which were satisfied by the law in case in Mississippi, which prohibited abortions after a certain number of weeks. I think it was 15. And that 15-week period would be pre-viability. The fundamental rule of Roe was that prior to viability, the only interference with the woman's right to terminate a pregnancy would be a matter related to maternal health. If they were doing something that jeopardized the woman's health, unsterile facilities, for instance, something like that, they might be able to regulate that you have to have a sterile environment. And that's very easy to understand. So what you end up having with Dobbs is a fundamental shift, and it throws the entire matter, people say, back to the states, right? And now is a question of legislatures deciding whether they want or not want to regulate abortion, whether they want to allow it at some time or not at other times, and to adopt laws that are rationally related to their power to regulate in this area. That understanding of the meaning of Dobbs is very important, because it recasts much of the debate about, or might recast much of the debate about, other issues that were previously decided by the court. 2 important caveats about this decision in Dobbs. The first is that Chief Justice Roberts concurred in the result. He agreed with the result of the decision that the Mississippi law was a valid exercise of government power to regulate a pre-viability abortion procedure and prohibit it. He did not agree with expressly overruling Roe and Casey. He wanted to wait on that. He said it didn't appear this case required that level of action. You could have upheld the Mississippi law and not reversed other cases. He favored a more incremental approach. And I understand his rationale and his limitation of how far he'd want to go piecemeal in this matter as a legal scholar, and he's quite a scholar. But in that particular case, the parties, both Jackson Women's Health and the state of Mississippi both asked the court to decide whether Roe was good law or not. So the parties in the case, not the amicus, not the hundreds and hundreds and hundreds of groups that filed briefs in this case, but the two principal parties themselves, expressly urged the court to make a clear determination of whether or not Roe versus Wade and Casey versus Planned Parenthood of Southeastern Pennsylvania were good constitutional law. Taking up that invitation, the court then decided it by a 5-justice majority, with a number 6 being Roberts joining in the final conclusion that the law was valid, but not in the part overruling Roe or adopting Justice Alito's entire opinion. Justice Alito's opinion is one of the easiest opinions to read in Supreme Court history. It doesn't contain any flowery language. It's a very straightforward discussion of the history of substantive due process and how it expanded into areas that some say are questionable. He expressly says this does not mean that we're ruling on other substantive due process cases like contraception, same-sex marriage, sodomy by same-sex persons, and other cases that relies on substantive due process to find fundamental individual liberties. He says this is fundamentally different. Those cases did not involve a unique fact that differentiates abortion from all other fundamental liberty questions, and that is the question of life. It's not that the court is proclaiming itself pro-life or pro-choice or against one or for the other, but that calls for a different understanding of the rationales by which society and government might want to step into these areas. Justice Thomas, in his concurring opinion, says something strikingly different. He was in the majority of the 5. He joined in Justice Alito's decision, but wrote separately to say what he has long argued and what Justice Scalia often argued, that substantive due process is an illegitimate concept and should not ever be applied. That all of these substantive due process cases, whether it's contraception, same-sex marriage, the right of extended family to live together in the same household, the right to marry, the right to choose the education of your children, all of that may well be freedoms, but they don't come out of the substantive analysis of the due process clause. He would say, if they exist, they have to arise out of the privileges and immunities clause of the Constitution. And in order to determine if they arise there, we'd have to have cases and litigate them out and brief them out and get all the arguments and so forth. So he leaves that floating out there, and that's caused tremendous controversy, as you might imagine, from groups who say, wait a minute, this case is going to open up all these other matters to being reviewed. I don't think that's going to happen. I think the issue of contraception is a closed chapter in American constitutional law, but I don't think the issue of same-sex marriage is a closed question. And I think that may get revisited. I certainly believe it should get revisited. It's very hard to find anything in the history and traditions of the nation that relate to same-sex marriage as a fundamental liberty. You could argue couples avoiding pregnancy. That's been something that goes back to the Egyptians, right? There's been contraceptive methods or believed to be contraceptive methods have been binding. There have been the common practice of withdrawal, so men are ejaculating outside the vagina. These are all forms, in some sense, of contraception. And I just think that chapter is closed in American constitutional history. But same-sex marriage, I think that's a topic that it's just somebody have to show me where the history and traditions of the nation demonstrate a foundation for that to become a fundamental liberty. If you want to say that new generations of people, educated in different manner, arising through different cultural times, have broadened perspectives that widen out our understanding of what it means to be human and to be fully human. This is what Justice Kennedy argued in the same-sex marriage decision. He says, and therefore are given greater insight and to recognize increased areas of individual freedom to act. And that can create a fundamental liberty. It's difficult to understand how that won't apply to prostitution or drug use, or plural marriage. Already, polyamorous relationships are common. There isn't a city in this country that doesn't have them, right? But people haven't institutionalized them by law. But that's may well be coming. The question is, if a legislature wants to adopt a law permitting that, a 3-person marriage, a 5-person marriage, adult consensual incestual marriage, why can't an adult man who's had a vasectomy marry his mother? They're in love. They have true affective relationship. I mean, we get repelled at the thought, and people will say there's great areas of exploitation that could occur in that, undoubtedly, and that may provide important government reasons. I think provide important government reasons not to allow such things. But if the concept is a broadening understanding of liberty that a different cultural context permits, why not? Justice Scalia proposed these exact cases in his dissent in Lawrence v. Texas. Perhaps the young man was adopted in his youth. He's never known his biological mother. He's 35 years old. He hunts out. He finds his biological mother, and they want to get married. I don't think any state law would permit that. But why isn't that a fundamental liberty under these more amorphous concepts that we hear about from Justice Kennedy? He's now retired from the court and been replaced by Justice Kavanaugh. But interestingly enough, Justice Kavanaugh was one of his clerks when Justice Kavanaugh came out of law school. Small world. The other aspect of Dobbs is the idea that this now puts the matter back into the control of the states. That's true and it's not true. Perhaps we'll get to that in the question and answer period. It's a little more complicated question, but Congress, the federal Congress, has constitutional powers that allow it to legislate in matters of interstate commerce. Abortion is certainly a commercial enterprise, and that may give it sufficient power to jump into that area. The reason Justice Alito said we return this power to elected representatives in the states is because that particular case was a state case, right? Mississippi. And therefore, the 14th Amendment due process clause that applies to the states, not the federal government.
That was an extremely thorough discussion, Father Tom. Thank you so very much for it. We will now begin the Q&A session moderated by Kiki Latimer. Kiki is an author, public speaking coach, editor, and teacher of homiletics. She received her BA from the University of Rhode Island in the oral interpretation of literature, psychology, and philosophy, and her MA in moral theology from Holy Apostles College and Seminary. She is an author, educator, presenter, and executive director of a crisis pregnancy agency. Her book, Home for the Homily, was published by En route Books and Media this year. With that, Kiki, we have about 10 minutes for Q&A.
Thank you. Thank you, Sebastian. Father Tom, that was an amazing presentation. It was very thorough and very enlightening. So thank you. One of the questions we have for you is whether before this summer's Dobbs decision, has the Supreme Court ever taken away a fundamental freedom previously recognized by the court?
Great one. Well, the answer is yes. It's a narrow thing. But first of all, what the court is saying, of course, in Dobbs is that it never was a fundamental freedom. It was a mischaracterization and a gross one by an ideologically driven Supreme Court of its day. So there's been a couple of instances in which the Supreme Court has said, for instance, I mentioned Lochner. It said that it was a fundamental liberty to contract in excess of the number of hours that were provided for in New York state law. They subsequently reversed that decision. So that was just a gross mistake. We had no business stepping into that. It wasn't our power. It was the court imposing laissez-faire economics on a system where economic regulation is given by the Constitution to Congress or to state legislatures. So the answer is yes, it has taken that action before. It's rare, of course. And the great example of it where fundamental liberties were not taken away when everybody thinks they should have been taken away was the Dred Scott decision, where a slave who made it to a free state was forced to be given back to his slave owner under the court's decision. I think almost every commentator today recognizes that it was one of the great gross mischaracterizations of our system that we did not recognize that a liberty that is at the time called a liberty by the Constitution, which was slavery, was not revoked in the case of an individual who had gotten out of slave territory. So I think Lochner is the case most on point for what you're asking.
The question from Francis here. What do you think about a legal definition of the human person which could protect the identity of the human race from, animal, human hybrids, frozen embryos, things like that?
Well, there is a definition of a human person, of a human being, and that's a genetic definition, and that's widely recognized and accepted. There's debates about the embodied sexuality or gender that are roiling our society today about that, but we know that the person is a human being by the chromosomal structure. But the human person, no justice of the Supreme Court has ever said that the unborn is a person. However, I would point out that Robert George, who is the very well-known professor at Princeton University, one of the McCormick Professor of Jurisprudence at Princeton, and John Finnis, very famous professor from Oxford, great theologian as well, they submitted a brief to the Supreme Court in Dobbs, in which they argued that our Constitution, based on the understanding of what the word person meant at the time the 14th Amendment was adopted after the Civil War, that we should declare, the court should declare constitutionally that the unborn are persons. Now, the court didn't do that, but that's a minority view, but there's increasing intellectual development arguing that if you follow the history and traditions of the nation, and go back to original language and meaning when the Constitution was adopted, that you would come up with something like a human life amendment to the Constitution without amending the Constitution, but just recognizing the word person in the due process clause includes the unborn. If that happened, then the millions of frozen embryos would be persons. So I think there are political and social reasons that are going to restrain the court from going down that road.
So one of the questions closely related was, does the Supreme Court have the capacity to do that?
Well, the Supreme Court has the capacity of judicial review. It's related to the concept and a doctrine that the court applies called judicial restraint, also taken from the Federalist Papers, that it not exceed the authority it's given, because no one has direct control of the Supreme Court. Right? They act, their lifetime appointment, they act. The only real remedy to the Supreme Court on a constitutional interpretation versus a statutory one is to amend the Constitution, which is a very difficult process, or to reverse the decision, which is what we saw happen in Roe and Dobbs.
Well, it's interesting.
The court can do it, but whether they're acting legitimately is a great debate.
I mean, it was really in Roe that the concept of person and human being got separated. Is that correct? In the first place?
I think the court characterized it as a distinction that had long existed, and that you could not determine what constitutes person for constitutional purposes, because it was so debated within religious and philosophical circles for a long time. And therefore, they said, what we know is that the living, breathing lady in Texas is a person. And we're not going to venture that. And they said, as a matter of constitutional dogma, they held that the unborn did not constitute what the word person meant in the Constitution for constitutional purposes. And that Professor George has directly challenged, and he is a giant in the world of bioethics and law. So I think this issue is going to remain a debate for quite a while. I have his brief up in front of me. By the way, I can send that off to Sebastian. You can perhaps post that up if members of the people in the webinar want to see it.
So my guess is we have room for about one more question, and I think this is an interesting one. If the recent Supreme Court decision, the Dobbs decision, gives states the powers to regulate abortion, how can Congress now adopt laws to limit some abortions, like the partial birth abortion ban?
Yes.
So
excellent question. Well, Congress, remember now, the Dobbs decision related to a state government act, and therefore it was analyzing 14th Amendment issues and what state governments have the power to do. It didn't talk about congressional power. Certainly, the President of the United States has authority to issue regulations and rules that govern national parks because Congress gave that authority to the President. And the President has the power on many issues because Congress gave him the power. So he could issue a rule that veterans hospitals and state park lands have abortion facilities. Congress can regulate interstate commerce. And because of the Interstate Commerce Clause, they could determine and they could preempt all of the states. And there are efforts underway now to do this. Congress is proposing this law now to congressionally codify Roe versus Wade. The President of the United States promised 2 days ago that he would make sure Congress federalizes Roe versus Wade by legislation, and he'll sign that law. So that battle is going to be fought tenaciously between now and January 1st, when the new Congress will be sworn in. Right now, there's a majority in the House of Representatives that would pass that law. There's not enough in the Senate to break the filibuster on it. But there's going to be a lot of effort between now and the next few months to get a federal law codifying Roe versus Wade. And it's beyond Roe versus Wade. They don't want to say a trimester approach. They want abortion to be unlimited until the moment of birth. So you can get a partial birth abortion or even by a hysterectomy the day before delivery. That's the legislation proposed by Senator Schumer that is trying to get through Congress now. But Congress has that power under the Interstate Commerce Clause.
Thank you, Father Tom, for the presentation. I'll send you the questions, those that remain, and then any responses you'd like to provide, we'll send out to the participants.
Very good.
That wraps up our QA. I'd like to thank Kiki for hosting the Q&A for us, and thank Father Tom for his excellent presentation. And we are, in conclusion, with Father Vincent Uke, a retired priest from the Diocese of Trenton, New Jersey, who will offer our closing prayer. Father Vincent?
Almighty God, we thank you for finally giving us a substantial message against making elective abortion as a constitutional right. May it be a wake-up call reminding us of the importance of love and responsibility in the Marriage Act. Help us to persuade all people to reflect not only on the value of each human life co-created by you, but to realize that each of us are co-created for a very important purpose. Now give us the grace as we move to putting limitations on direct abortion to gradually take away the scourge from the world by moving those with hardened hearts to see God's will for us and his generous gift to see the unfolding of each life's purpose for all of us. We ask this through our Lord Jesus Christ, your Son, who lives and reigns with you in the Holy Spirit, God forever and ever.
Amen.
Amen. Thank you so much, Father Vincent. God bless everyone, and we'll see you for the next webinar in October.
Hello, God's beloved. I'm Annabelle Mosley, author, professor of theology, and host of Then Sings My Soul and Destination Sainthood on WCAT Radio. I invite you to listen in and find inspiration along this sacred journey we're traveling together to make our lives a masterpiece and, with God's grace, become saints. Join me, Annabelle Mosley, for Then Sings My Soul and Destination Sainthood on WCAT Radio. God bless you. Remember, you're never alone. God is always with you.
In Thank you for listening to a production of WCAT Radio. Please join us in our mission of evangelization. And don't forget, love lifts up when knowledge takes flight.